welcome to Crime in Court. This is another episode of the Delphi homicides, Indiana versus Richard Allen. And this episode is titled Nicky Caught Withholding Evidence from Defense. And that is obviously Nicholas McClellan that I am referring to. So let us get started. Please hit that like button if you don't mind. And trying to shrink myself here and it didn't work. Okay. So we have a few filings to get through. Obviously, we're going to be talking about Nick McClelland potentially hiding some evidence. So let's read through these. We have up first is the defendant's verified motion to preserve and produce specific evidence. So if you recall, a while back we read through another filing. It wasn't a verified motion, but it was a motion to preserve evidence. Of course, Judge Cole denied it. She said it wasn't no, that was something else. She said that it wasn't their responsibility or something, and that they would only preserve what is required of them to preserve by the rules of, professional conduct, whatever. So this is a second request, basically. So let's get started reading. So Richard Allen, by counsel, now comes before the court with his verified motion and moves this court to order the state of Indiana to preserve certain specific evidence and to produce that evidence to the defense. In support of this motion, Richard Allen states the following. On February 12th, 2025, Richard Allen's counsel, Andrew Baldwin, met with inmate Reese Davis, which we'll talk about in more detail in another episode, but he's going to be a primary focus in this one. So, Reese Davis, who is located at Newcastle Correctional Facility, he is an inmate there. I think it is for some meth or something, I want to say, is the reason he's in there. Selling or making, or I don't really particularly know, but uh, he's in there for quite some time. All right, so during their meeting, Mr. Davis informed Attorney Baldwin of the following. That he, Reese Davis, was in the unique possession of having met with both Keegan Klein and Ron Logan during their stays at Newcastle facility. So Keegan Klein, if you recall, you know what? Hold on one second. Let me pull up. I had a slideshow for you guys a while back, and I'm going to pull it up for you. So one second. All right, perfect. So what I have for you on the screen, I did a who's who of Delphi, which I kind of went through all of all of the different suspects and whatnots, but this was before we knew. So this was like the Patrick Westfall, the Vinlanders. We went through all of those. But here we have, oh, where'd he go? Logan. Okay, so we have Ron Logan here, who I also did a episode just on him. He was the property owner where the girls' bodies were found. Not only that, but his alibi did not check out. So we know that now. His home, his property was searched by the feds, and then that's about the time that the Indiana State Police told the feds, you know what, we got this, you guys can leave. And they did for some reason. Or perhaps it might have caused some suspicion, and perhaps maybe some of the feds stuck around watching them. I hope, but I'm not hopeful. I mean, I'm hopeful that that happened, but I don't have a lot of hope that it happened because I don't think it did. But anyways, so Ron Logan, we've gone over. We went over not a search warrant, the probable cause affidavit for his home. We don't know what was actually found and if anything was found. I believe some firearms were probably located on his property, as were Brad Weber, who I don't even have him in here as a potential suspect, but now we know after trial that he was the one driving the white van, and his home was searched also. and he had a firearm that would have been consistent in um, making similar tool marks, let's say, as what were found on the bullet casing at the scene that they claim is Allen's. So, anyways, there were several suspects, including Ron Logan, Brad Weber, who lived all in that area. So, just to give you an idea of who's who. So, Ron Logan owned the property on which the girls were found. They were actually found about 1,400 feet from his home. He was investigated by police early on. We don't know what came of that, though. He allegedly asked a family member to lie about his whereabouts, so there was a uh, his his alibi consisted of he had to drive some garbage to the dump, and he did that, I believe, on his own. But then he said he went to a fish store and he told his cousin to tell the law enforcement that they drove him. This male cousin, he said, "You tell law enforcement that you drove me." And he had the cousin, I guess, admitted to law enforcement that he was lying about Ron Logan's alibi. So there's that. Also, his phone puts him near the Monon High Bridge because he never left, and his whatchamacallit, his alibi didn't check out. So it's possible that he did not go to the fish store, or he did go to the fish store, but he wasn't there for the amount of time that he said he was there, which is most likely what happened here. Also, his ex-girlfriend has suspected that he was involved. We have video. I played it on my channel at one point or another, or I think it was on the Logan episode, where the ex-girlfriend, said that she was very afraid of him. He was very violent. He hit her like the last time she saw him, he hit her with a wrench in the head or something along those lines and injured her quite badly. And she said she was quite afraid of him. So that's what we have there. And then he also walked with a limp, which is possibly the limp that we see in Bridge Guy, the video, the interloping video, the video of Bridge Guy that we just see on a loop. It literally is just the same step on a loop. It's not actually a series of steps by the individual, as internet sleuths have determined. So it is possible that they did that to hide the limp. I would say maybe law enforcement, if it was Ron Logan on the video as Bridge Guy. At this point in time, this was before the trial when I created this, so he was a solo suspect at the time. But now we know that he and Keegan Kline may or may not have known one another. So Keegan Kline is incarcerated currently for child rhymes with corn. And he it was also soliciting images of underage girls. As you can see, this is Keegan Kline, but he was pretending to be Anthony Schatz. So these are the pictures of the guy that he was pretending to be. I mean, talk about night and day, right? But anyways, um, I guess this guy was a model, and now he's like a firefighter or something, an EMT firefighter. Um, but anywho, and he was not happy to be used. It's catfished to catfish young girls. But anyways, that's who Libby was supposedly, she thought she was talking to, was this Anthony Schatz, when really Keegan Kline is who she was talking to, and she saw him. Whoops, she saw him or was talking to him that day, that morning. Keegan Kline was potentially one of the last people to have actually spoken to Libby. So that's who Keegan Kline is. So he admitted to creating the fake Anthony Shots profile to communicate with underage girls with the expectation of receiving soliciting pictures of these girls. So, questioned about an incident involving a young girl giving the Anthony Shots her address. So, like, there was an incident that happened a few weeks after the girls, I want to say it was after, it might have been before, but I think it was after the girls had been, after their lives had been taken. This Keegan Klein was talking to some underage girl, and he got her to give an address to her house. She later saw someone hiding in the shadows looking in her bedroom window, told her parents about it. That's what happened. He got caught for that. Um, he told somebody that he was supposed to meet up with Libby, but she never showed up that day. But that was not disclosed to law enforcement or put out, in the media anywhere that he told someone in conversation, I guess, because that would be a hearsay argument, but still. Whoops. I didn't mean to change the screen. All right, so he also communicated with Libby via social media that day. He was one of her last contacts. I said that already. He faces now 30 years for child, rhymes with corn, and exploitation. Um, there's also this other individual, Jerry Anthony Klein, who is this individual's father, Keegan's father. He had a criminal past with convictions of sexual harassment, battery, and theft. He made repeated sexually explicit calls to women. Him, 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 him. He never seen any charges or searches that we know of regarding that. I mean, we only know about the other underage girl that he got the address from. So I don't know, but there you have that. All right, so this Reese Davis, who we've talked about in other episodes, he is an inmate. Like I said, he reached out to Andrew. Well, he was in contact with Andrew Baldwin. I don't want to misquote it or whatever. I don't want to state it incorrectly, but one of them was in contact with the other, and they talked about the Delphi homicides and um, Reese's role in hearing confessions in prison from both Ron Logan and Keegan Klein. How Ron Logan and Keegan Klein are related, other than Reese Davis was incarcerated with both of them at separate times, at separate points in his incarceration, I don't know. But they both confessed to him, apparently. So here is Andrew Baldwin's meeting, February 12th, 2025. He meets with Reese again. He says during their meeting, during the meeting between Reese and Andrew Baldwin, Mr. Davis informed Attorney Baldwin of the following: that he was in the unique position of having met both Keegan Klein and Ron Logan during their stays at Newcastle Correctional Facility. He, Reese Davis, talked with Ron Logan about the Delphi homicides on multiple occasions over the course of time. Logan confessed to his involvement in the homicides along with two other people. Could it have been Keegan and his dad, Jerry? Or were there some Vinlanders involved? Is Ron Logan a Vinlander? I have so many questions, and we don't know the answers to any of this. And a man is sitting in prison for these crimes. So let's just realize where we're at here. We have all these questions, no answers, and silence surrounding the case, and a man sitting in prison for 130 years. All right, during those conversations, Logan provided certain details of the crime that only the actual perpetrator would know, but never divulged who the other two people involved in the homicides were. In or around March 2024, Keegan Kline was placed in the same general area as Reese Davis. At some point, apparently learned that Reese Davis had talked to Ron Logan while Logan was incarcerated. So he was first incarcerated with Logan. Logan confesses. Then he gets moved, or somebody, people get transferred all the time in prisons. I, I'm assuming. And so Keegan Kline then comes into his unit, or comes into his facility, and says, "Hey, I heard you were talking to Ron Logan. What were you and Logan talking about?" So that's kind of suspicious already in and of itself. Over time, Klein began questioning Reese Davis as to Reese Davis's conversations with Ron Logan and whether Logan had ever mentioned his name to Reese during those conversations. So, did Logan talk about me? Was Ron Logan talking about me? I want to know. He was trying to fish for information about what Reese knew. Reese Davis began to realize that Klein may have been one of the other members of the crew that Logan described as being involved in the homicides. Over time, Keegan Klein began to reveal information about the Delphi homicides that corroborated details Ron Logan had revealed to Reese Davis several years earlier. So Keegan starts saying things that only Ron Logan knew years ago. How is that possible? Some of the details Keegan Kline provided to Reese are the types of details that could only be known by someone involved in the homicides. These conversations between Reese Davis and Keegan Kline occurred all the way up to the guilty verdict. So he's in prison up until like October, November of last year, having these conversations with Reese, asking, "What do you know? Who do you know? What did Ron Logan tell you?" So there, he's trying to figure out what Reese knows about the homicides. So these conversations occurred between Reese and Keegan all the way up until the guilty verdict, at which time Klein expressed his relief that he would no longer be a viable suspect in the homicides due to Richard Allen's confessions. So Klein was up until Allen's guilty verdict. Keegan Kline was worried that he might be considered a suspect in the crimes. Not like they couldn't add more, say that there were more people involved at this point. We could still go back and say, hey, there might have been more people, but then that kind of defeats the whole, oh, there was only one person and it was Richard Allen state narrative, which in the beginning they always thought it was multiple people, and suddenly, out of nowhere, after Allen was arrested, oh, it's only one person. I never thought it was multiple people. I never said that. But then you go back and you can see all of law enforcement's interviews talking about it being multiple people. So there's that. Not knowing whether Richard Allen could be the third person involved in the homicides, Reese Davis asked Keegan Kline whether Allen was the third person involved in the homicides. Kline replied that Richard Allen was not the third person and had nothing to do with the homicides. How does Kline know that unless Kline might have been involved in some way? Keegan Kline further revealed to Reese Davis that he and Logan knew each other through the sharing of child rhymes with corn that they shared on burner phones, and that further so that's how these two are related. Keegan Kline and Ron Logan. Ron Logan is deceased at this point, but Keegan Kline is still incarcerated. But that's how they knew each other, was that they were both into child porn. And they shared that on burner phones, and that further, Klein and Logan would see each other every 3 to 6 months so that Klein could assist Logan with using the burner phones because Logan was inept working with electronic devices. So Klein was like the nerdy techie guy that would go and hang out with Logan every few weeks to make sure that his burner phones were working or set up properly or whatever. I don't know. So Reese Davis further explained that once blah, 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 blah. It's a lot to say in one sentence. Let me start over. Reese Davis further explained that once Keegan Kline began revealing his role in the homicides sometime in the summer of fall of 2024, before Mr. Allen's October trial, Reese Davis, began sending letters to Nick McLeland providing many of the details of his conversations with Keegan in 2024 and Ron Logan in 2027. So Reese is like, oh, sounds like they might not have the right guy on trial. I'm going to reach out to the prosecutor and tell them what I know. So he writes to Nick McLeland this summer and fall of 2024 before the trial ever took place. Reese Davis indicated that he believes he sent as many as 8 letters to McLeland's office. 8 letters, potentially. To McLeland's office to McLeland's office, and presumed that McLeland was sharing the contents of those letters with Richard Allen's defense team. So Reese Davis is writing to the defense, or writing to the prosecution, and assuming that the defense is just getting these letters because that is what you're supposed to do as a prosecutor, and it is called a Brady violation if you do not. So, did we just catch Nick McLeland in a Brady violation? I think we did. Attorney Baldwin met with Reese Davis on March 27th, 2024, and learned very limited information from Reese Davis, who encouraged Baldwin to watch a videotape interview law enforcement conducted years earlier. At their February 12th, 2025 meeting, Reese Davis further admitted that when Attorney Baldwin met with Reese Davis on March 27th, 2024, so they met twice, once in 2024 and then once again in this February of this year. So Reese Davis admitted that when he first met with Attorney Baldwin, he did not provide all of the details that he knew at the time to Attorney Baldwin for 2 reasons. So he didn't trust Attorney Baldwin, and he didn't want to give away all of the information that he knew, is what he's saying here. So he had not yet heard of the many details that Keegan Kline ultimately provided him, including that Keegan Kline was involved in the crime and that he and Ron Logan, or that he knew Ron Logan, sorry, so that he knew Ron Logan, and that too, that time he met with Attorney Baldwin in 2024, Reese could not be sure whether Richard Allen was one of the other 2 people that Ron Logan described as also being involved in the homicide. So, if you recall, Ron Logan here, all the way up here, Reese and Logan meet in prison. He reveals the fact that Logan confesses. This is way back when, and he says that there were 2 other people, possibly. He doesn't meet Keegan until much later. So at that time, he thought it could be, those 2 other people. He thought that one of them could have been Richard Allen. But then once Keegan Kline comes into his facility and starts confessing to certain things, then he realizes, oh wait, I don't think Richard Allen is the guy. So it took him a while, and it took many conversations about it, and it probably came out like not all right away. They probably didn't have heart to hearts talking about this like in depth every night. It probably was like drips and drabs. He would confess to things, and all of a sudden, Reese starts putting it all together. So at the time he met Attorney Baldwin, he didn't know whether Allen could have also been one of the two people. Mr. Davis stated that he was guarded during their March 27th meeting with Baldwin because he did not necessarily want to assist Richard Allen's defense counsel if Richard Allen was one of the three men that Ron Logan stated was involved in the homicides. Again, in his 2024 meeting with Baldwin, Reese Davis told Baldwin that Baldwin could learn the details of what Reese Davis told law enforcement by watching his videotaped interview. So he didn't give information at that time. He just told Baldwin, go watch my interview, which I'm sure he never even received. So there's that. So he says, go watch my videotaped interview that law enforcement should have in their possession from when they interviewed Davis sometime years before. At their February 12th, 2025 meeting, Reese Davis was shocked to learn that Baldwin had never received the videotaped interview. Are we? Not at all, because we know Tricky Nicky's little games, and now we know that he has committed Brady violations, which means he's probably gonna get disbarred or might have some misconduct, criminal charges to deal with, perhaps. I'm not sure what is going to happen to him, but I hope something for Brady violations. Also, they go on this Brady violation the Brady list, and basically it's prosecutors and law enforcement and anyone who has not, has purposely not turned over information, data, evidence, which could have helped the defense in some way, been beneficial to their defense, or been exculpatory. And that is what this is. This would absolutely help Richard Allen's defense. This would be something that is obviously exculpatory if Ron Logan and Keegan Kline did this. Richard Allen didn't. So this is obviously exculpatory and would be very helpful for the defense, but yet Nick did not turn it over. All right, so following the March 27th visit, did I read this? With Reese, the next day, March 28th at 11:49 p.m., Attorney Baldwin emailed both Nick and Stacy Diener requesting that they turn over law enforcement's videotaped interview of Reese, which Davis presumably provided the details of Ron Logan's confession on videotape, but he didn't provide it to Attorney Baldwin, which is why he had to go watch the videotape. To date, the prosecution has never provided any videotaped Reese Davis interview to the defense, nor explained why it has not done so. That's a Brady violation. Nor stated no such videotape exists and have ignored the request. So at no point have they even been like, I don't know what videotape you're talking about. They're just ignoring the requests from the defense counsel. I'm sorry, what? Can you do that? Are you allowed to just ignore requests from the other side? I guess so, in Carroll County. The approximate 8 letters that Reese Davis claims he sent to McLeland in the months leading up to the October 2024 trial would contain multiple layers of exculpatory evidence, which the defense could have used to further its investigation as to whether certain facts contained in those letters could be verified through crime scene photographs, digital data, and a variety of other means. So could they determine that any of the things that Keegan Kline or Ron Logan admitted to Reese in prison, were they true? Were they things that only the perpetrator would know? That would be really important to find out. Defense counsel has never seen the Davis letters, nor known of their existence until after the trial. Remember, they were sent before the trial, which means they absolutely had them in their possession and they should have been turned over. So, yeah, they haven't seen them, they've never seen them, and didn't even know about them until after the trial when defense counsel met with Mr. Davis on February 12th, 2025. Also, the prosecutor has never informed the defense counsel of the existence of any such letters. Brady. I mean, they covered their tracks. We've never seen them, we didn't know about them, and the prosecutor never even informed us until, or has never, ever informed us of such letters ever having existed. So this is the first time we're hearing about it and we're bringing it up now. On the evening of February 12th, 2025, Defense Counsel Baldwin sent an email to Nick McClelland and his in-house investigator. Steve Mullen is his in-house investigator. If you remember, Steve Mullen was part of the investigation that put Richard Allen away, or that tried to, convict him. So on the evening, sorry, I got caught up in that. On the evening of February 12th, 2025, Defense Counsel Baldwin sent an email to Nick McClelland and his in house investigator, Steve Mullen, requesting they produce both the Davis letters and any video recordings in their possession of any interview with Reese Davis. McClelland's response was vague, non responsive to the defense request, and did not indicate whether McClelland had received those letters at all, none, nor whether he sent those letters to the defense. So he didn't answer their question whatsoever, gave a really vague non response. In other words, Mr. McClelland never confirmed nor denied the existence of said letters. Neither did he confirm nor deny that he provided those aforementioned letters to the defense counsel. So he didn't confirm or deny that he had them or that he provided them. So he's pleading the fifth as a prosecutor. Can prosecutors do that? When they're in big trouble, maybe. On February 13th, 2025, at 3:54 p.m., Attorney Baldwin sent another email to McClelland asking straightforward questions. Did you receive multiple letters from Reese Davis in the months leading up to Richard Allen's October 2024 trial? And if so, did you turn those letters over to the defense? These should be questions easily answered and quickly answered. If McClelland never received such letters, he should know that answer immediately, since Reese Davis claims that he sent the letters directly to Mr. McClelland. If McClelland did receive such letters, he should know the answer immediately. Further, so he should be able to answer it and not give these vague answers. Furthermore, if he did receive such letters, he should very quickly be able to identify the dates and that he sent those letters and when he sent them to the defense and how he sent them to the defense. So, did you photocopy and email or and mail them? Did you email them and have them scanned, email them? Like, what was the process? You should know these things. This is part of discovery. You should know when you got it, how you got it, when you gave it over. As of the time of the filing of this document, McClelland has failed, blah, 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 I cannot read today. As of the time of this filing of this document, McClelland has failed to answer these simple, straightforward questions. The defense has reviewed all e-discovery from March 2024 to the present, so everything that they received from the prosecution, to determine whether the prosecution provided the Davis letters to the defense to determine if those letters were hiding among other discovery. The defense found no such letters penned by Reese Davis addressed to Nick McClelland in the e-discovery. It's not there. The defense has reviewed all emails during the applicable time frame to determine whether McClellan ever forwarded an email with attached letters from Reese Davis. No such emails exist. The defense requests that the court order McClellan's office, as well as any law enforcement agency, to preserve any letters from Reese Davis in their possession and further to turn them over to the defense immediately. The defense similarly requests the court order McClellan's office, as well as any law enforcement agency, to preserve any video recording of an interview with Reese Davis in their possession and further to turn such video recordings over to the defense immediately. The defense is concerned, and I would be too, that without an order from the court, the prosecution and or law enforcement may lose, and I'm doing air quotes, may quote unquote lose the Davis letters, as well as the videotaped interview of Reese Davis, or the state of Indiana may refuse to turn them over because they're bad for the state. The defense's concern is well founded based upon law enforcement's history in the case of losing evidence as documented before during this particular trial, including claiming that they taped over certain important videotape or video interviews. So if you remember the Vinlanders, Brad Holder, Patrick Westfall, Elvis Fields, all of their interviews were accidentally / magically recorded over. And they were suspects early on. The defense can produce a witness with admissible evidence that in the months before Mr. Allen's trial, the prosecution received some number of letters from Reese Davis and that those letters had been given to the people investigating this case. So there's a witness that says that these letters exist. That's probably Reese. The defense has a constitutional right to know of the existence of the letters that Davis wrote so that the defense could conduct its own investigation concerning the contents of those letters, including conducting depositions that would naturally flow from the facts alleged in those letters. So the defense was deprived from the opportunity to investigate things within those letters and to depose certain people. Keegan Kline, Ron Logan, like that should have been enough probable cause, I guess, for the judge, enough of a nexus for her. Hopefully, you would think confessions would be enough of a nexus for her to be able to be like, hey, look, it's these guys. We need to be able to talk about them at trial. We need to be able to conduct depositions before trial. We need to investigate this, which we know Judge Gull is in on it, and she wouldn't allow it anyway, so that's why we're here. Had the defense known that the Davis letters before trial, had they known about the Davis letters before trial, it could have the defense could have used those letters to further its investigation, present them to the court at the hearing on August 1st, which was where they discussed the third party suspect culpability, and factored the information contained in those letters into its trial strategy. So all of this they were deprived of. They weren't able to talk about third party culprits at trial. They weren't allowed to bring up Ron Logan or Keegan Kline, and uh, they weren't allowed to just not the absence of knowing about these letters hindered their ability to defend their client. Had the defense received those letters after the verdict, then the defense could have incorporated those letters into its motion to correct error if it had received them after the verdict, but it did not, and it could not, because we already did the motion to correct error, which has been denied. So they can't even correct the error on this because they didn't receive it until afterwards. So, for the foregoing reasons, the defendant respectfully requests that the court order the prosecution and any law enforcement agency to preserve any letters from Reese Davis in their possession to immediately turn over to the defense any letters from Reese Davis in their possession, to preserve any video recordings of interviews with Reese Davis in their possession, to immediately turn over to the defense any video recordings of interviews with Reese Davis in their possession, and to preserve all records in whatever form and communications, electronic or other, including emails and text messages pertaining to Reese Davis. And that is signed by Andrew Baldwin. And then we have an addendum to the verified motion to preserve and produce specific evidence. This is just a 2-pager, so it's quick. Comes now, and it was about 20 days later, so I want to say this one came out, February 14th. 10 days later, February 24th, they have an addendum. Comes now Richard Allen by and through counsel and files this addendum to the defendant's verified motion to preserve and produce specific evidence. In support of said motion, Allen states the following. So this is coming from the defendant's statements. Then on February 14th, 2025, Allen filed his verified motion to preserve and produce specific evidence related to certain letters and video that the defense had been told were sent to the prosecutor's office and contained exculpatory evidence of which the prosecution had never provided to the defense. The person that informed the defense of this evidence was Reese Davis. Since the filing of that document, the defense met with a witness on February 22nd, 2025, to sign an affidavit concerning his knowledge of the letters that Reese Davis claims that he sent to the prosecutor's office. Attorneys, so there's a third, so Reese Davis and Attorney Baldwin both attest to the fact that they had this meeting, but there's also a third person that can say, Reese wrote these letters and this is what happened. He actually signed an affidavit to that. Allen's attorneys attach a copy of the affidavit of James Winters, marked as Exhibit A to this pleading, as further evidence that the defense has a good faith basis based upon due diligence that the state of Indiana had in its possession certain exculpatory evidence before the October 2024 trial that it did not turn over to the defense, and to further reinforce its request for this court to order the prosecution to preserve and produce those letters to the defense, as well as the video related to any law enforcement interviews of Reese Davis, and to set the matter for a hearing. Wherefore, so now they want a hearing, which we will get a formal request also for a hearing, a second formal request for a hearing. So Richard Allen files this amendment to the verified motion to preserve and produce specific evidence that he filed February 14th, as well as the attached affidavit of James Winters. All right, so here's the affidavit of James Winters. Comes now, affiant James Winters, and swears and affirms the following. My name is James Winters, and I am 67 years of age. I was a dairy farmer in northern Indiana for 50 years and currently raise Holstein steers. I have never been arrested. I have never been in any criminal trouble. I don't drink or use illegal drugs. I understand that lying in this affidavit would and could result in a charge of perjury, since I am swearing that the things I am saying in this affidavit are true. The things I am saying in this affidavit are true. I have no reason to lie and would not lie. In the fall of 2024, my nephew, so this is the uncle of Reese, in the fall of 2024, my nephew, Reese Davis, asked that I contact the Carroll County Clerk or the prosecutor's office, so Nick McClelland's office, to find out if they were receiving the letters that Reese had written and addressed to the prosecutor. So not only did he take the initiative to write these letters to the prosecutor, he also had his uncle go and make sure that the prosecutor was getting them because he wasn't receiving any kind of response. Reese told me that the reason that Reese was asking me this favor was because he had written several letters to the Carroll County prosecutor about the Delphi homicides and was expecting that those letters would prompt the prosecutor and/or law enforcement to meet with him to discuss the information contained in those letters. It was my understanding that Reese began writing those letters in the weeks before the man who was accused of the Delphi homicides was going to trial, so Richard Allen. It was my understanding that Reese began writing those letters in the weeks before Richard Allen was going to trial in the fall of 2024. So he didn't write the letters until after Richard Allen was arrested and about to go to trial, but he was receiving confessions long before Richard Allen, or maybe Richard Allen was already arrested at that point, but I'm not sure because it doesn't quite say. But we know that Logan started confessing long ago to Reese. I did, in fact, call the Carroll County Prosecutor's Office, and I did talk to a nice lady. This guy's so great. I love him. I don't know if she was a clerk or a secretary or something else. I called the prosecutor's office sometime in August, September, or October of 2024. I believe it was closer to October. I told the lady who answered the phone my name and further told her that I was calling on behalf of my nephew, Reese Davis. I then asked if she knew whether Reese's letters had been received. The lady immediately told me that she was aware of Reese Davis's name and indicated that they had received, I believe she said, multiple letters from Reese. The lady further indicated that every letter she had received from Reese Davis she had passed on to the people in charge in the investigation of the Delphi homicides. I don't think Slicky, Tricky Nicky was expecting this level of due diligence by Reese Davis. I really don't, because Nick is caught with his hand in the cookie jar for sure. I mean, there's no other way around it. And he's going to try, but he actually will possibly admit that he had the letters and just didn't turn them over. The lady further indicated that every letter that she had received from Reese Davis she had passed on to the people in charge. I asked the lady if she would let the investigators know that I called and that Reese wanted to talk to them, and he had expected someone would talk to him, and that she said that she would relay the message to the investigators. I don't remember the name of the lady who answered the phone. I would not lie for anyone, including my nephew. This is just the truth. This affidavit consists of 3 pages and 20 paragraphs. I did not prepare this document. Rather, it was prepared by Attorney Baldwin because I would not know how to prepare such a document. I love this guy. Mr. Baldwin typed out what I told him. Furthermore, I know that Mr. Baldwin is not my attorney, nor is he Reese's attorney. Everything stated in this document is true, and I am willing to testify in court to these facts if I am asked to do so. I swear and affirm, under penalties of perjury, that the statements made in this affidavit are true and accurate, and that is signed by a James F. Winter, uncle of Reese Davis. Again, what is Nick gonna say? He is caught with a hand in the cookie jar. Here is Nick's response to the defendant's motion to preserve and produce specific evidence. This was written 4 days after the addendum was received, or at least it was filed then. So, all right, so now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland and respectfully ask the court to deny the defendant's verified motion to preserve and produce specific evidence and their motion to set this matter for a hearing in their entirety. The state would ask the court to consider the following. That as the court has already outlined in its February 14th, 2025 order, that there is no authority for the defense to request that the evidence be preserved by the state and that the state would ask the court to deny the same. So that this was their first request of asking for preservation of the evidence. She denied it. Judge Gull denied it. And then this is now their verified motion, their second motion, and having to do with the whole Reese letters. All right, continuing on, he says that the defense in their motion also asks the state to produce specific evidence demonstrating exculpatory evidence for the defendant. That the state has outlined this in previous filings, but discovery is evidence in a case that the state intends to use at trial or evidence that tends to exonerate the defendant, referred to as exculpatory evidence. Not all information gathered in an investigation is discovery. No, it's not, but this would absolutely be discovery. That most of what Reese Davis told Attorney Baldwin is false. Oh, okay, so he's lying now. That attorney Andrew Baldwin had an opportunity to fact check the information that Reese provided to him, but instead chose to put the information in a public motion without verifying its truthfulness. That's because you won't let him verify. You didn't give him the opportunity to verify because he didn't know about these communications. That the state contacted the Department of Corrections and had the department send a list of all outgoing mail from Reese Davis to the Carroll County Prosecutor's Office. Said list herein attached as Exhibit 1. That as the we don't have that, unfortunately. That as the court can see from this list, Reese Davis did not send the state 8 letters. He only sent 3. So those it's okay that I didn't turn them over to the defense because it wasn't 8, it was only 3. It's okay that I kept those from the defense. Are you kidding me? One letter on October 4th, 2025, one letter on October 15th, 2025, and one letter on October 21st, 2024. Do you guys believe that? Do you believe that Reese could confuse 8 and 3? I think it was probably more than 5. If I were to guess, because you wouldn't guess 8. 8 is like your in between 5 and 10 guess. So he probably sent over 5. So there are probably letters that Nick McClelland is still hiding, is my assumption. That the state was able to recover 2 of the 3 letters sent from Reese Davis. The letter sent on October 4th, 2025, and the letter sent on October 21st, 2025. So where's the one from the 2024th, and why weren't you able to recover it? Why did he use that language? We were only able to recover it. Like, what does that mean? You deleted the emails? Is that like now you're destroying the evidence, so you had to go back into your servers and try to recover it? Are they destroying evidence? This little weasel, Nick McClelland? That's what that says to me. So the state was able to recover 2 of the 3 letters, which they provided as exhibits, which we also don't have. That the letters sent by Reese Davis are not exculpatory for Richard Allen and therefore are not evidence for or discovery. So he thinks that it's not exculpatory if some other third party confesses to a crime that some other person is on trial for. He does not he's a prosecutor, right? He should know the definition of exculpatory, but I guess he doesn't. Anyways, never gonna get through this because I'm getting so angry at everything he says. All right, next thing, the letters in fact accuse Richard Allen of committing the homicides. So now Nick McClelland is saying, no, Reese Davis has it completely wrong, and the letters actually accuse Allen of the crimes, not Keegan Kline and Ron Logan, even though that is what Reese has told us. So it doesn't make sense. It is not exculpatory evidence for Richard Allen. It is inculpatory evidence for Richard Allen. Okay, lie some more about it, Nicky. See how that goes when, especially in a written court filing. See how that goes for you. That the letter dated October 4th, 2025 is titled Information on Keegan Kline and Richard Allen. The letter goes on to implicate Richard Allen in the homicides, stating that he set up the meetings with the girls. He is the one that took the girls' lives, the youngest girl, and that once the girls were taken, that Alan then moved the bodies. That was part of the confession from Ron Logan. He's using details from Ron Logan's confession and saying it was actually Richard Allen who did that, not Ron Logan. With what proof are you even alleging that? He's got nothing to prove that, and he has no sworn affidavits or anything to contradict anything that the defense said in their filings. That in the letter dated October 21st, 2025, Reese Davis states that Ron Logan, Keegan Kline, and Richard Allen are responsible for the homicides. He goes on to state that attorney Andrew Baldwin is an ignorant lawyer who is hinting me to lie for him and his client, saying that I should know how it is. Do we believe this? I think this is a blatant lie coming from the prosecution trying to make attorney Baldwin look bad, trying to make him look unethical. I think this is a blatant lie. I think if they do have these Reese Davis letters, I think they're forged. If these letters say the things that Nick McLeland is alleging that they say. That although the state has diligently searched all the evidence involved in this case, the state cannot locate or even verify that the second letter sent from Reese Davis was received by this office. Okay. But wouldn't that have been the first letter? Because that was the October 24th date. I mean, the October 2024 date, whereas the other two letters were in 2025. No, this that's impossible. That's an error. And I knew that was in there too, and it fooled me. Fool me once, fool me twice. These all should be 2024, I'm assuming. 20 So October 21st, 4th, and what's the third one? 4th, 15th, and 21st. All of 2024. So those are all incorrect. I was not thinking as I'm right. I'm like, yeah, that's October 2025. Nope. Got it, Heather. Stick with the language on the page. All right, so this moving on, that although the state has diligently searched all the evidence in this case, the state cannot find the second letter. So that's the 15th, the letter from the 15th they can't find. So they have the 4th and the 21st, but the 15th is what they can't find. Okay, that makes more sense. The James Winters did call the prosecutor's office on October 15th and near October 21st. So he called there twice apparently to verify that this office had received the letter sent by Reese Davis. However, at that time, he did not indicate how many letters that Reese Davis sent or when he sent them. He just called to confirm that the state had received some letters from Reese Davis. Further, he indicated to this office that both Keegan Kline and Reese Davis had been subpoenaed by the defense. Wait, he indicated that Keegan and Reese had been subpoenaed by the defense to testify at trial against Richard Allen. Okay. That the state's response to the motion to correct error, the state referred to the evidence that Reese Davis supplied to attorney Baldwin as not matching the physical evidence found at the scene. So the state is saying in their response to the motion to correct errors that the things that Reese Davis is saying don't fit up. They don't match up with the scene. So they're saying the state therefore finds the information that Reese Davis supplied not credible. So it's Nicholas McLeland's decision to decide what evidence is credible and not credible, apparently. This is scary, guys. This is really scary if you're paying attention. That there is zero evidence found in the investigation that Ron Logan and Keegan Kline knew each other or shared or exchanged child rhymes with corn. That this, other than they talked about it and Keegan Kline admitted to it and that they knew each other. that the state was able to obtain recent communications between Klein and various civilians where Keegan Klein denies the allegations set out by Reese Davis herein. What communications do you have of Keegan Klein with various civilians if he's in prison? Maybe he denied it via over the phone, perhaps, but any kind of other communications, isn't he prevented from texting and things like that? So who would he have been talking to and denying the allegations? And so what if he denies it? That doesn't mean that he didn't do it. Further, in these text communications, Keegan Klein states that Reese Davis is an idiot. I've only talked to him maybe 2 times. He's one of the guys in prison that tries to write all different prosecutors and get time cut on people's cases. And here we have the prosecutor trying to discredit Reese Davis by saying he's just an idiot. He contacts everybody. He's always trying to get time cut off of his case because of trying to, make himself and interject himself into other cases, is what they're saying. It's laughable. Keegan reiterates the point in several of the responses that he texts. That as the court can see from the state's exhibit 1, Reese Davis did send several other letters out to other attorneys, which adds credence to statements that Keegan Klein made about Reese Davis's behavior. That attorney Andrew Baldwin could have requested this information from the Department of Corrections to verify or debunk Reese's statements before he made his filing, but chose to file the motion without verifying the allegations. The attorney, Andrew Baldwin, by his own admissions, interviewed Reese Davis on March 27th, 2024. That attorney, Andrew Baldwin, had every opportunity before trial to depose Reese Davis and had every opportunity to call him. Didn't they try? They were denied everything that they tried to do. And they had the opportunity to call him as a witness at any hearing or at the trial. They didn't know about him because the letters were not turned over. You know what I'm saying? The letters were not turned over. They didn't know what questions to ask because they didn't have the correct information in front of them. And when Baldwin actually met with Reese the first time, Reese was not forthcoming with any information and said, "Go watch my police interview," which was never turned over to the defense. So you can't blame them for not having the information. The only one to blame is Nick McClellan for not having that information. Then Attorney Baldwin had every opportunity to call him before or to depose Reese before trial and had every opportunity to call him as a witness at any hearing and chose not to. In fact, from James Winter's statements to this office, Andrew Baldwin had, in fact, subpoenaed Reese Davis to testify at the trial for Richard Allen. Whoa, what happened? I lost my spot. Hold on. Sorry, my page jumped and I totally lost my spot. All right, next is that attorney Andrew Baldwin now wants to present these statements from Reese Davis as irrefutable proof without any evidence or corroboration to back up the statements. That Reese Davis's statements to attorney Andrew Baldwin do not match the statements that he made in the letters that he sent to the state. In those letters, he does not say Richard Allen is innocent or not involved. Quite the opposite. He says, now my page blew up. He says Richard Allen participated in the homicides and is guilty. That's actually the opposite of what Reese Davis is telling Andrew Baldwin. So who's lying? Nick has lied to us multiple times. So I believe Reese. That evidence that contains allegations that the defendant is guilty with no proof of those allegations is not exculpatory evidence and therefore does not have to be turned over. So someone else's confession to a crime that you've been alleged to have committed I guess that's not exculpatory to Nick McClelland. I can't believe this. I can't believe what I'm reading. That there is not a video interview of Reese Davis that exists within Discovery or is within the state's possession, because you guys probably deleted that too or taped over it. That even if this was evidence the defense wished to use at trial, it was not newly discovered evidence. The defense knew of Reese Davis, had interviewed him, had subpoenaed him for trial, and chose not to present the evidence to the court. Further, the state has mentioned in previous responses any information pertaining to Ron Logan or Keegan Kline falls under the state's motion in limine concerning third-party motive. The defense had 3 days to present evidence to meet their burden for third-party motive. Did you not get the part where they weren't able to present this as evidence or call him for this hearing because they didn't know about it? Did you miss that part? No, you did that on purpose. You kept it from them on purpose, Nick. And that's why they weren't able to call them to that 3-day hearing to talk about the third party motive. They mentioned Ron Logan but failed to meet their burden with the court. They chose, also because they didn't have all the information, they didn't have the confession about Ron Logan either. They chose not to present this evidence in that hearing because they didn't have it. They also did not present this evidence when they renewed their motion during the trial. This now seems to be an effort by the defense to use this motion to circumvent their burden concerning third-party motive. Give me a break. That none of the evidence that the state has gathered from Reese Davis is exculpatory, nor is it discovery. That's not up to you, buddy, to decide. That this motion seemed yet another attempt by Attorney Baldwin to push a certain narrative to the public, specifically the online world. So again, he's disparaging. This is unreal. I can't even get my words together. They have repeatedly disparaged, disrespected, and even questioned the integrity of Andrew Baldwin in this filing. They called Ricky a liar, Reese a liar, and they're calling Baldwin unethical, pretty much. That's basically the essence of this filing from the state. Let me start that from the beginning. That this motion seemed yet another attempt by attorney Andrew Baldwin to push a certain narrative to the public, specifically the online world. He seems to file these types of motions with very bold allegations that he never verifies the information, nor does he present any evidence to back up the statements. I'm sorry, but what? He had sworn affidavits from people. He's met with Reese Davis. Like, there's nothing that he's done that's unethical or wrong here. He's putting in public filings things that are going on in this case, and Nick doesn't like it because it is displaying Nick's corruption, his own unethical behaviors, and so therefore he's just disparaging another lawyer who's literally just doing his job trying to defend his client to the best of his abilities, knowing that Richard Allen is innocent and has been railroaded by law enforcement and the prosecution and the judge. Sorry. Okay. This is unfortunate that motions by the defense in this case have come to this point where they present statements from an inmate as fact without any legal or evidentiary support. They're not stating it as fact. They're saying, this is what we discussed. This is what we talked about. This is what happened. This is what I know. He's not doing anything other than investigating and doing his job. Wherefore, the state of Indiana, by prosecuting attorney Nicholas C. McClelland, respectfully requests this court deny the defendant's motion in its entirety without a hearing for all other just and proper relief in the premises. The state affirms under the penalties of perjury that the above is true. Well, good. He signed it and everything and says it's true. so he can be caught in his lies. That's good. Um, whoops, let me read this one first. I had them out of order. Okay. We've got two more things to read through. So we've got a verified request for a hearing on the defendant's motion to preserve and produce specific evidence. So on the 19th, so this was actually before the state's response even, they did put in a verified motion to preserve or verified motion for a hearing. So comes now, or I'm sorry, it's not a verified motion. It is a motion. Oh, it is a verified request for a hearing. Okay, never mind. I take my words back. This is confusing because it's verified and verify. I don't know what the difference is, but it's a verified request for a hearing on a defendant's verified motion to preserve and produce. So I think this just means they are requesting this again, possibly, because the first time it got denied. All right, so comes now Richard Allen by and through counsel and moves this court to set a hearing on his previously filed defendant's verified motion to preserve and produce specific evidence. In support of said motion, Richard Allen states the following. On February 14th, Richard Allen filed his verified motion to preserve and produce specific evidence. On the 18th, this court ruled on several defense motions, including Allen's motion to correct errors, but has yet to rule on Allen's February 14th verified motion to preserve and produce specific evidence. Carroll County Local Rule 18B2 states the following. The state shall disclose to the defense any material or information within its possession or control that tends to negate the guilt of the accused as the offense is charged or would tend to reduce the punishment of such offenses. The defense provided a verified motion detailing why it believes that the state of Indiana possesses and possessed before trial material or information within its possession or control that tends to negate the guilt of the accused as to the offenses charged or would tend to reduce the punishment. Furthermore, suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or punishment, irrespective of the good or bad faith. So, regardless of whether Nick McClelland did this on purpose or not, suppression of this evidence, not turning this evidence over, violates Richard Allen's due process rights. So, just that alone, these charges should be dropped. I mean, I think so. And in a lot of cases, if the trial were still proceeding and this were found out later, I mean, serious ramifications could happen and even up to the point of charges being dropped or dismissed. So these are serious allegations when a prosecutor does not turn stuff over. It happens all the time because they're in control of the information and they don't want to turn over information that hurts their case. So is it really the best process that attorneys are prosecutors are the gatekeepers of the information? No, something needs to change. I don't think it's right the way that it's done. I think defense should have everything. Why isn't everything discovery? In my opinion, it just should be. Anyways, moving on. The prosecutor has not responded to the defense's requests to either confirm or deny the existence of approximately 8 letters from Reese Davis, as well as one video of an interview of Reese Davis, and has further not responded to the defense's request as to whether the prosecution claims to have produced those items to the defense. At this point, they hadn't responded. Because of the prosecution's failure to respond to the defense's simple request to either confirm or deny the information detailed in the previous paragraph, the defense would request a hearing for the prosecution to put on the record whether it possessed or possesses these items, and if it claims that it did possess those items, whether the prosecution provided those items to the defense. So they want a hearing because Nick McClellan was not answering them, and it worried, I'm sure they had concerns about that. So Nick McClellan was just ignoring their questions about where this stuff came from, how'd they get it, did they turn it over? So because they didn't answer, they were like, the defense is like, we need a hearing. We need to put in a formal request that we need a hearing. Said hearing will also assist this court or future reviewing courts to determine whether the state has suppressed exculpatory evidence and whether the evidence at issue is favorable to the accused because it is either exculpatory or impeaching. The evidence was suppressed by the state either willingly or inadvertently. So even if he didn't do it on purpose, it's still a problem, even if it's not intentionally. And the evidence was material to an issue at trial. Richard Allen recognizes that this court has denied his motion to correct errors, but as one remaining matter exists before the court, he would seek a hearing on this remaining matter. What do you guys think she's going to do? Well, wait no longer. We have an order. This came February 24th, and she says, defendant's verified request for hearing on defendant's verified motion to preserve and produce specific evidence filed February 19th, reviewed and denied without hearing as premature. Keep that thought in mind, whatever that phrase is. Denied without hearing as premature, as the state is entitled to respond within the timelines governed by the trial. So at that point, had they responded? No. So on February 24th is when she said, I'm not going to deny the hearing yet because it's premature and the state should respond. So then she kind of pushed them to make this response. She forced Nick McClelland to put in writing and basically lie, perjure himself in an affidavit that he signed, a legal document that he signed stating that all of this is true, everything that they're saying is false, Andrew Baldwin and Reese Davis are all false, and blah, blah, blah. All this stuff that he's lied about, yeah, that he signed in an affidavit. Haha, he signed it on the 28th of February, which means I think that he's in trouble. That's what I think. What does Grok say? I had this question. So, first of all, my question was, did Judge Francis Gall rule on Richard Allen's motion to preserve and produce specific evidence filed on 2/14/2025? Here's Grok's response. It's a perfect response because it helps us understand the whole verified for motion thing too. So, as of the most recent information available, Judge Francis Gall has not ruled fully on Richard Allen's motion to preserve and produce specific evidence filed on February 14th, 2025. However, she has denied a related request for a hearing on that motion. So that was what we just read, was the denied without hearing as premature. Specifically, on or before February 27th, Judge Gull denied the defendant's verified motion for hearing on motion to preserve and produce specific evidence as premature. This means that while the request for a hearing was denied, the underlying motion to preserve and produce specific evidence itself has not yet been ruled. So the very first motion that we read, having to do with all of the things that Nick did not turn over, revealing all of that, that has not been ruled on yet. So they filed this on the 14th. Their amendment was 10 days later, but even before they filed their amendment, they filed the request for a hearing. And so that's why she denied it, because the other one has not been ruled on yet, which, based on her wording, denied without hearing, as the state is entitled to respond To me, that means she wanted to see the state's response to this. She wanted a response. She wasn't going to let Nick just let this one go without responding. So she wanted a response. She got it. Now he's sworn in to his lies. Therefore, no final decision has been made on the motion as of March 2nd, 2025. The motion for preserving evidence, that one remains pending at this time. So that is the latest in the debacle of discovery, the craziness of what's going on in Delphi, the shenanigans, the whatever you want to call it, dirty Delphi, corrupt Carroll County. I mean, we could call it basically anything, but it just baffles me that we're still here and we're still arguing for this man's innocence when all of these errors and things have been going on, and Judge Gull is just like, nope, I don't see it. All I see is the defense's errors, and even though they're not errors, and anything that the prosecution does, she just sweeps it under the rug. It's insane to me. So I don't know what is going to happen here, but this, though, is telling because she wanted to hear a response from the state about these Reese Davis letters not producing discovery. So I don't know what's going to happen. If I were to guess or make a bet, I would think that Judge Gull is just going to deny everything without hearing, anyways. So why she even bothered to write this up, I don't know. But I think she was trying to get a response out of Nick. So there you have it. That's my take. Let me know what you guys think. I'm always interested and curious to know what you guys think, theory wise, for this case, and what's going on in the specific filings. Let me know what you think of those also. And I will see you guys in the next one. Thanks for watching and take care. Bye now.